Judge, call the case?
Yes. All right, the court is calling 2021 CR. Sorry, the court is calling 2021 CR 7575, State of Texas versus Jose Parada. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Guillermo Lara for Mr. Parada, Your Honor.
And are you Mr. Parada?
Yes.
All right, we have an interpreter here. To the interpreter, if you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
You can lower your hand if you'll state your name for the record.
Mariana Rios.
All right, we are here for sentencing. A jury found Mr. Parada guilty of the charge of manslaughter on September 19th. The jury ordered that his punishment be assessed at 10 years in the prison, that there be no fine, and that they're requesting that he be placed on community supervision. And of course, the court will follow the jury's verdict, which is for Mr. Parada to be placed on community supervision. However, the court did order a PSI, so the court could make appropriate conditions for probation for Mr. Parada. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Judge.
Any objections to the PSI report, state?
None from the state.
Defense?
Judge, only on page 9, the third paragraph, beginning, I just need the court to, and then there's a word there, confine in me. I believe they,
I'm sorry, where are you speaking of, counsel?
it's paragraph 3 on page 9 at the top, Your Honor.
Yes.
Towards the end of that paragraph. I just need the court to confine in me. It's just a typo. It's confide in me, but I just wanted to bring that to the court's attention.
All right, thank you.
That was it, Judge.
All right, thank you. All right, state, do you have any witnesses?
No, Your Honor.
Defense, any witnesses?
No, Your Honor.
All right, state, anything you wish to say on behalf of suggested conditions for Mr. Parada?
As far as conditions, no, Your Honor, other than the length of supervision, we would be asking for the maximum for 10 years. You heard the facts of this case. This is the situation where
Voice up.
Mr. Parada put himself in the situation that he had many opportunities to avoid this scenario. He brought a gun into the situation, caused the death of an individual who was trying to get away from him. The jury obviously felt that he was wrong in his actions because not only did they find him guilty, but they assessed the maximum prison sentence. And so we're asking that you match that and do a 10-year supervision period also.
All right, defense?
Yes, Judge. Judge, I believe there's a misstatement of what the jury actually wanted. I mean, whatever the jury wanted, specifically with respect to the term, I think they were confused with what they were asking this court when we received the question, but I guess that's beyond what we're here for. Judge, we're asking the court to grant Mr. Parada 5 years probation, and the reason why we believe that that's appropriate is he is not a menace to our community. He clearly works hard for his family, as well as abiding by and making sure that he follows all rules. The court has had no issues with him whatsoever on release at this point, Judge. He's always reported. He's always been to court. And he's the type of man that's going to follow through with his word. He works for his family, he works for himself, and he wants to make sure that the court knows that as far as this situation is concerned, he understands, and if he could take it back, he would. He said that clearly in the PSR as well. If he could go back, he wouldn't follow this individual. If he can go back in time, but he understands that that's not possible. And he's trying to live his life at this point in a positive direction, knowing that it still affects him daily. It affects his family daily. And as we've noted, Your Honor, there have been multiple drive-bys to his house at the location. And when it was asked in the punishment phase for Mr. Parada with respect to how does he know that that location is associated with Michael Cepeda? Well, Your Honor, the individual, Sabrina Espinosa in this case, would frequent that location where that car would drive to when it would go and discharge the firearm at Mr. Parada's home. It's in her video. Not only is it in her video, it's been corroborated that that house specifically belonged to associates of Mr. Cepeda who continue to harass Mr. Parada. He's made multiple reports. And we're just asking for the court to consider that in making its determination. We understand that the jury has made their decision and he just wants to move forward with his life. And again, making positive steps for himself and his family. And he knows that he carries that with him and is going to carry that with him for the rest of his life, Judge. He's just asking for the court to give him an opportunity and continue them with 5 years of probation.
Your Honor, if I could just
Yes.
briefly respond. The only thing I want to respond to is the part about the drive-by shooting that keeps coming up. Mr. Parada had multiple opportunities to talk about that on direct, and I even crossed him on it. He couldn't tell the jury or the court how he associated that with Michael Cepeda. The whole purpose of that was somehow to fling mud at the victim even after his death. There was no video of Sabrina admitted into evidence. Counsel was testifying, and Judge, I don't think that should be something that you factor into your consideration when deciding what his probation term should be.
Judge, if I may respond, it's not mudslinging, Judge. These are facts. And they're not something that I would make up. I'm not going to be disingenuous to the court as to a fact that exists. It's not something that I would do. It goes to my character. And Judge, I can assure the court that I would not mislead the court on that issue.
Okay. Is there anything else from either side?
No, Your Honor.
No, Your Honor. Thank you.
Mr. Parada, is there anything you wish to say to the court? Let me have you raise your hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you
Before God.
can lower your hand, state your name for the record.
José Parada,
Jose Parada,
All right, what would you like to say?
que me den una oportunidad
that you give me a chance
para sacar mi familia porque yo soy el que sustento mi familia.
to be able to get my family ahead because I'm the one that supports my family.
A todas las tengo en colegio, pero yo he trabajado arduamente
I have them all in school and I have worked very hard.
y es lo que quiero yo y
That's what I want today.
All right, any questions?
No,
Vince?
no.
State? All right, this is what the court is going to do. The court is going to follow the jury's request that the defendant be placed on probation. Court will follow the jury's request that there be no fine assessed. So the court will sentence you to a $0 fine, 10 years in the prison, suspended and probated for 8 years. Proof of employment within 15 days. There's to be no employment as a home health care with minors, regular reporting, regular UAs, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be field visits 1 time per month for 3 months. We'll see how that goes probation. If everything is fine with the field visits within 3 months, then you can suspend the field visits. And I'm going to add anger management course. Probation, is there anything else that he needs?
No, Your Honor.
Mr. Parada, is there anything else you need from the court in order to be successful in this probation?
tengo confianza en mí porque yo nunca
That you trust me because I have never, that's all.
All right. Ms. Parada, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that did you review that document with your attorney? Did you understand it?
Yes,
And did you sign it?
yes,
All right, because this was a jury trial, you do have a right to appeal. Do you understand?
sí.
yes,
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sí.
Yes,
All right. Is there any victim impact?
No, Your Honor.
All right, Mr. Parada, good luck to you.
thank
Your
you.
Honor. Thank
You're
you.
welcome. All right, can I see the? Pettis?
You'll be able to find it.
Would you like her to adjourn?
Yes. All right.
Hold on. Wait.
Have you conferred with the state? Oh, she can come up.
Briefly, Your Honor. Well, I always tell people, listen to the people with badges, not me. Thanks.
All right, court is calling 2022 CR 9288, State of Texas versus Patricia Pz. Could I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Andrew Fraley, Ms. Perez.
All right, have you had a chance to confer with the state?
Briefly, Your Honor, I was just retained this morning.
Mhm.
And after speaking with my client, finding out we retained knowing she had a warrant, there was a miscommunication about court on Friday. I would like to ask the court to reinstate the bond and provide some evidence
Okay,
as to my client's situation.
I will tell you this, there was no miscommunication. I gave her a setting of when to come back and she did not appear. Twice. So, she's gonna go into custody. They will, Ms. Ferguson will have a PR bond done for her. Once I review that PR bond, and since she's in custody, it should be fairly quickly when they get that done. I'll review the PR bond and you all can make your arguments, whether or not a bond should be reinstated or whether or not there should be a bond issued for her. All right.
Thank you.
So Ms. Ferguson, on Patricia Pz, we need a PR bond evaluation done. Yes, just the criminal history. And I do that because there have been changes, as you know, and that's the quickest way for me to get the case on docket if we do the PR bond. Otherwise, I can have it referred to Judge Carruthers.
Oh, no, Judge, the fastest way would be beneficial. and we
All right.
appreciate that. If there's one thing I could
Yes.
approach the court on the record and introduce this email that I got.
Mhm.
Letting the court know, just first page is that she successfully completed residential treatment.
Mhm.
Second page is her discharge plan. The third page on here, Judge, lists her medical and mental conditions. I
Mhm.
just want to point out for the court, just so we have it on the record, medical issues, she has a colonoscopy bag, her psychiatric issues, bipolar, schizophrenia, and PTSD. And after speaking with her yesterday and today, I can assure you that the bipolar part is definitely going through a couple of swings. And the schizophrenia, Judge, she has made some numerous statements to me that would lead me to question whether or not she is mentally competent. So we will proceed with those. We've asked the court in terms of any PR bonds. You wanted to wait for this, didn't you?
Oh, yes, because I don't have anything before me.
No.
And what I can tell defense counsel is that as a defense attorney and even as a prosecutor, I would take note of anyone who has any type of mental health issues. And I would always take that in consideration and try to get them help as quickly as possible. However, I cannot have people who are not abiding by the rules of the court. Number one, being reporting to court. Number two, having ignition interlock for a DWI third and all of the things that go along with being charged with the DWI third. So we will come back on what date, Ms. Ferguson? Well, when do you think the PR bond will be, evaluation will be done for her?
No, not for you. For another case.
All right. All right, so let's bring this back in 2 to 3 days.
I could be here tomorrow, Judge.
Oh, that's not 3 days. All right, let's give them a 2-week reset, but if it's ready before then, we'll have her here before then.
Can I ask the court to set a bond today?
No,
So there's no bond set at this time.
no, I don't have any information to set bond. All right, Ms. Ferguson. All right, so we're gonna come back on October 18th at 9 a.m. And just check in with Ms. Ferguson in 2 days to see if it's available, because if it's available, we'll put it on the docket immediately.
I'll be here anytime the court needs me to be.
All right, thank you. All right, who's here? I'm Brianna Gutierrez.
Your Honor, I'm here representing Ms. Gutierrez. Ms.
All right,
Gutierrez
she needs to
is
come
also-
forward. All right, where are we on this case?
Judge, the state tendered an offer. I believe that they discussed it, but are not accepting.
All right, counsel, do you have all the discovery?
Yeah, I believe we do, Your Honor.
All right, so state, I'm gonna need a discovery of acknowledgement done today.
Yes, Judge.
And Ms. Ferguson, can I have a 1 month reset for a plea deadline for Ms. Gutierrez, please? All right, Ms. Gutierrez, November 9th is going to be your plea deadline date. What that means is that the court will not accept any plea bargain agreements past that date. If you decide to enter into a plea bargain agreement past that date, the court will only accept it with good cause. Otherwise, you have to plea open to the court. Do you understand? All right, thank you. All right, thank you.
Yeah.
Hi,
Good morning, Your Honor.
good morning. All right, Mr. Allen, have you spoken to the state about this and whether they have the records?
I spoke to Mr. Sanders. I do have some records. We're seeking others. They have no objections.
All right. Well, I want to know where the records are because I don't want us to be here for trial and then the records are not had. So I want to know.
They're in San Antonio. It's my understanding he's been to multiple hospitals. And so they're here in San Antonio.
All right,
Oh, sorry.
Mr. Sanders, this is off docket. Do you know about all of the health records for, and is this for Mr.
The
Trimble?
complainant, yes.
Yes, do you know about the health records for Mr. Trimble?
I don't. I
All right,
can find out.
so defense is saying they want health records. So are you able to,
And Judge, I was gonna subpoena those records myself. It was just so, because they may deal with HIPAA issues. I wouldn't be able to receive them without the court signing off.
okay, no, I'm definitely gonna sign off on it, but I wanted to see if the state already had access for these records or if the state could get them quicker. So he's requesting the medical records of your complainant, Mr. Trimble. So is your investigating getting those records or no?
No, Judge, we weren't. I believe because of the way that it was indicted, it's indicted as just deadly weapon, and so we didn't need them for our case.
They've already turned over some medical records as well, Judge.
And again, state, I think, I could be wrong. I think it may be quicker for you to get the records than Mr. Allen. So if you could look into that, please.
Yes, Judge,
Yeah.
I will.
All right. And Mr. Allen, if you will talk to the state about that.
Yes, sir.
And we are coming back on jury trial for November 28th.
Yes.
Ms. Ferguson, we're scheduled for jury trial for this on November 28th. Can you give us a date? And your client doesn't have to be present.
Okay.
Give us a date in October just for a discovery, because I don't want us to come back on November 28th and we don't have the records. All right, so we'll come back on October 31st. Your client doesn't have to be present. It's Henry Knight. It's 2022 CR 8435. So we're still going to keep the jury trial date for November 28th. This is just for defense counsel to see if he has the medical records and his client doesn't have to be present. Yes. You're welcome. Donna, can you check on Suzanne Kramer and Tom McCray?
That's okay, that's okay. I know. Because it was a sign of the rejected, yeah, and so we don't want to leave it up to the judge. Because I think the problem in this case, you understand. No, we both have, yeah, we both have. Okay, and have you guys, I know you also talked about this, have you interviewed her without her? We would. It's okay. But this is one of those where I have to gently go forward and there's no. Stop it, though. I don't want to say that. I take the little bills. Okay, so what do we do? Tell us. Okay. And so, and I'll tell him that anyone that was there. It was a sign, so. I mean, if you want to take a friend, sure. Like everybody, if they give me a position, I'm never taking a friend. I'll take it down. It's a lot of risk. It's a lot of risk. I mean, talk to them. Okay. And I'm gonna talk to him. I can just make my recommendations. Okay. How are you? I'm blessed and highly favored. Look at yourself.
I don't know about being either. But I guess, I woke up alive, so that's always a good sign. Angel Rodriguez. Like, did y'all file that injury to the child, please? He said it's we can get that filed. Oh, really? Yeah, he doesn't want to see the baby, but he didn't even do it.
Did he do the injury?
He didn't even do that, he did.
We could reverse it.
Folks, probably better to put in for- I'm sure the parents are reaching out because every time you call in, compliance. And that I see everybody. That's also how I'm ordering the Spanish people in there. I'll be back.
Pressure over.
Once you put downstairs. Grandma used to refer to her private areas. Let them touch my downstairs.
It's still, well, the problem is, which would be- Good year, Gunner.
All right, Kadir Gunner,
Who's presently?
come forward. All right, what is happening with this case?
We've conferred, Judge, previously. There's been an offer on the table. It appears that we cannot come to an agreement as far as the relates to the plea bargain.
All right, your plea deadline date, Mr. Gunner, has expired. The court will not accept any plea bargain agreements in this case without good cause. Or otherwise, you have to plea open to the court. Do you understand? All right, are you requesting a jury trial? All right, Ms. Ferguson, when can we put this on the jury trial date? All right, so you're going to jury trial on October 31st.
Yesterday, I got a setting for October 31st in Kerrville. I'd rather stay here, even though it's a pretty drive. I'm just informing the court. Yesterday, they told me October 31st, and I was like, hey, doesn't anybody know what's happening? Apparently, that doesn't carry weight.
That doesn't, but
And I
you,
know it doesn't here, Judge, but I'm just letting you know, they told me yesterday. If I could have the first week in November,
Let them know you're gonna be in jury trial and impact court
okay,
here.
okay.
And if they need a phone call from us, we'll gladly call.
I'll
them.
reach out to them today, so. thank you.
All right, thank you.
Thank you, Judge.
All right, and Ms. Ferguson will give you your reset form.
Okay, thank you.
Welcome. Thanks for dressing appropriately for court,
I'm
Mr.
trying to get in the spirit. You know, I can only wear this maybe 1 or 2 times a year.
Okay, see, he thinks I'm talking about him. You know, attorneys, you all should all dress appropriately for court. I'm talking about your client
Oh,
dressing
absolutely,
appropriately.
Absolutely.
Yeah.
I thought you were referring to the color of this clothes.
Oh, let me just tell you, I admire the color. You know, sometimes men will only wear black suits or either they do the navy with the red tie, as though there are no other color combinations out there. So no,
I'm trying to be festive.
your color combinations are a rival to Michael Sawyer and his brother. And let me just tell you, that's rare because Michael always comes dressed
He does.
and, you know, off the pages of GQ. Michael, you have competition for the dress.
Is he gonna do it? I didn't talk to my guys around there. I'm gonna sit down next to him, okay?
All right, have a good one.
Thank you, John.
Hey, this is Michael going out to the office. Can you do, your safety case number and see if- Yeah, yeah, yeah. I'll take it easy. 2, 4,
Aliah Palus. All right. All right, why were you late for court?
I'm sorry, my phone's off, but I made it here as best as I could. I was using the GPS without any Wi-Fi.
All right, but you've been here to this courtroom before, so what does the Wi-Fi for your phone and GPS have to do with coming to court?
I don't remember how to get here. I live by the Lackland Air Force Base. So it's a pretty far distance for me. And on top of that, I don't have much gas in my car.
All right, that's why Via is available. I don't know what people have against the Via bus. I've ridden the Via bus. It's nice sometimes to sit back and let somebody else do the driving. You can't be late for court again, you understand? All right, so what are we doing with this case?
Your Honor, the pretrial diversion agreement has been sent to her. I just checked in her email box and it is there. She just needs to sign it and I need to send it back.
So when is this signing going to happen?
I have to give it a
We just tried when we were in there and her phone is cracked, so, and hard to see. She should be signing it this morning and then I can send it back in. And then once the orientation happens, it'll be.
So how is the signing going to happen? Because you all tried it and her phone is cracked,
My mom has a laptop at home now.
but it hasn't been, is your mom's laptop your same email, or are you going to transfer your email? I understand you can sign in from emails at different locations. Is that the plan?
Yes, Mom.
All right, and when is that going to be done?
As soon as I get home.
All right, Ms. Ferguson, can I have a reset for PTD, please? All right, we're going to come back on November 9th. All of that needs to be signed. If it's not, then PTD is probably not going to happen for you. You understand? All right, so we're going to come back on November 9th.
Thank you, Your Honor.
You're welcome.
She excused?
After she signs the reset form.
Okay, thank you. Okay, I love it. Let me know if you have any questions.
Sergio Martinez. Good morning.
I'm gonna ask you one more time. Since I've met and this is, you won't consider it the end for those people to talk about. That is more than I can hold. I was thinking now, and I'm not even from that sense. The whole chick said she was gonna sign an affidavit and then prosecute it. She was mad at us, how many people.
Rico Fernandez. Rico.
Who are they? You really want me to- I don't know. You don't know how to get a second edition.
It was just.
No, I haven't. He said he didn't do it. I'm like, no, okay. Do you have at least one report that they can show me?
Yeah, well, yes. I mean,
He said, I never told him that. I never did. I never did.
you bring the visits to somebody. We're not gonna,
Well, not gonna give it to him, but.
we're not gonna recommend.
No, he's not.
We're not gonna recommend. Yeah. Okay.
Can I move him down? Move down so you can look at the report. Sit on that.
All right, and which attorney is this? Okay. Let's reset it for 30 days. Let's see where they are. Okay.
Hi, Judge, hypothetical question. If we have someone who's on bond that has a warrant,
Well, on bond, but he's got a warrant, but he's not in custody.
but there's no. He has a warrant, so bond needs to be set. Is that a situation where we can do the whole PR application or is something else?
He's not in custody. So what I was hoping for was just to get a bond set, and that way I could then possibly walk him through our life. So that he wouldn't have to go to custody.
He needs to come in, present himself.
Thank you, Judge.
You're welcome.
I just want the line. Like, where's- Obviously. I didn't.
That's the one I'm thinking, right?
I'll go order. Yeah.
That's it.
There was no. There's not. With mom. Like technical.
All right, Daniel Flores. Why are you late for court? All right, so here's the thing. You cannot be late for court. I can make sure that you're here on time if you want to, and how that will be accomplished is you'll be coming over from the Bexar County Jail dressed in orange or red or whatever color they classify you as. You understand? So we're supposed to be here today for a jury trial, and then there's supposed to be some school records that are outstanding. Where are we on those school records?
We have the school records, Judge. Full disclosure, this was Michelle's case, and so I first reviewed it today. I noticed that there was a stain exam done, but we didn't have any lab results. So I just called over to the lab. There are lab serological and DNA reports, and they were able to tell me over the phone that in their analysis, they did find unknown male DNA. So with that being said, I'm emailing the detective, letting him know that he needs to get a search warrant for the defendant's buckle in order to have this compared to the results of the same kit. I apologize to the court. It was an oversight on our part. And, I believe it could potentially be exculpatory based on a review of the CPS records and other allegations. And so I think it's something that we need to have done in order for both sides to have a full understanding of what necessarily we're dealing with.
Judge, that's correct. I think we're also missing the doctor records, the Patricia Cornelius.
So there was one doctor that we've been trying to contact over and over again. We haven't been able to contact her. I believe it's Beatrice.
Okay, so we're gonna go on the record, because I see where I've had discovery date set. Court is calling 2021 CR 9660, State of Texas versus Daniel Flores. Can I have parties announced for the record for the state,
Michael Villarreal, the state.
for the defense?
Bridget Gossip for defense.
And are you Danielle Flores? So we've had a discussion off the record, and that's in regards to outstanding discovery. So what outstanding discovery is needed?
So I'll go in reverse order of what we did off the record. There is one doctor, Cornelius, Beatrice or Beatrice Cornelius. Marina has been, who's the victim advocate, has been trying to reach this doctor in order to find out who to submit the subpoena to. We've been unable to contact them to get that information. In talking with Marina this morning, she indicated that this doctor, she believes, is associated and works for a university hospital. We did subpoena those records in between last setting. We did receive them, and those have been turned over to defense, as well as Edgewood ISD school records, as well as Edgewood ISD police records. So all of those were requested between the last setting and today, and 3 of those have been, all the issues that we were able to successfully serve, those records have come back and been tendered to defense.
Okay, so the record is clear. There are no other school records, outstanding school records. Is that correct?
That's correct, Judge. The only item since last setting that's pending is the Dr. Cornelius Beatrice.
Okay, I want to go step by step because I write everything down. So no more school records.
Correct.
All right. So then you have this doctor.
Cornelius Beatrice.
All right. So do you have any idea of when those records, are you trying to locate where this person is?
Yes, Judge, and that's the issue. It's not that we've had the subpoena issued, but we've been unable to serve them. Marina has had a contact number and has been calling multiple times, but has been unable to reach the person or the office.
All right, so I've Googled and it's Beatrice Cornelius. They're at University Hospital.
Yes, that's what Marina indicates, and so
Okay. All right, so then I'm assuming that everybody knows where to subpoena her. Or they can just schedule appointment at this number that's listed on Google, schedule appointment for her, then show up and say, surprise, I'm actually here to obtain some records. We've been trying to get in touch with you.
yes, Judge, and I think these records actually might be contained within the university hospital records that we have, because she is at University Hospital.
Okay,
But I have to, the records understandably are voluminous, and so I haven't been able to confirm that information.
all right, and just so the record is clear, that's Beatriz.
Yes.
Okay. So do you have any idea of when those records, you'll be able to have those, any type of approximate time frame?
I'm hoping, Judge, where it's not the court's problem, it's not the defendant's problem, it's the state's problem. We are in between investigators right now doing our investigator leaving, as being short staffed. But hopefully within the next 30 days, I can beg and plead an investigator that's not assigned to me to have that completed.
Okay, so we need that. And then what else? You mentioned DNA off the record.
Yes, Judge. And so in reviewing the case today and attempting to confer with Ms. Garza, I realized that the same exam had been completed. Swabs and clothing had been taken during that examination. I called over to the crime lab to see if they were in fact submitted to the crime lab. The crime lab was able to tell me over the phone that the same kit as well as clothing had been submitted, that the serological and DNA analysis had been completed on those items, and that it resulted in an unknown male DNA contributor. And so, knowing this information now, I'm contacting the detective to have him complete a search warrant for the buckle for the known standard of the defendant in order to have that completed for analysis. The crime lab was very gracious to, is in the process of compiling the discovery packet and is going to be emailing that to me. As soon as I get that information, I will obviously turn that over to Ms. Garza.
Okay, so we're actually set for jury trial today. It appears that this is not going to jury trial today. So defense, do you have any objection to the court resetting the jury trial date and extending the plea deadline date until you have this information?
No, you're on.
All right, so Mr. Flores, I'm going to extend your plea deadline date because today was your plea deadline date. And we are going to extend the jury trial date. So state, not on a conservative basis, but how long do you think, because I'm not working in the laboratory, I don't know how backed up they are with regards to DNA testing, but how long do you think that will actually take?
Judge, I think it would be no less than 60 days because I'm gonna have to get the detective to get the standard and then submit it to the lab. I'm going to obviously communicate with the detective that this is of his utmost priority. And then I will call the lab and let them know that once it's submitted, it needs to be expedited as soon as possible. In previous discussions with the lab about other items, in order to expedite it, they're usually telling me about 2 months at the earliest for them to be able to get it completed.
All right. So, Ms. Ferguson, I'm gonna want this case recalled for 45 days. Gotta see where we are on this discovery. But Mr. Flores, when this goes to, once we get all the discovery and your attorney has ample time to speak with you, and I don't know, defense, you may wanna have experts based upon what you see. But once everybody has all their information, we're gonna proceed swiftly to jury trial, you understand? So we're gonna come back in 45 days to see where we are on this discovery, and we'll go from there. All right, Ms. Ferguson. So we'll be back on November 18th, and Ms. Ferguson, just put that in the system for discovery. All right, is there anything else from either side?
No, Judge, I appreciate your patience.
Hey, I'm taking it out of my pocket, but I'm wearing pants today, so I only have 2 pockets. So some has been taken, but I know people will share.
Thank you, Judge.
All right, so we'll see you back on that date, okay? Make sure you're on time.
Okay, thank you.
All right, you're welcome.
Okay, so I've done some mind twisting. We're going to take your time and dinner or something. We're only putting one day, right?
Yeah.
Okay.
As previously.
Previous to Tinder? I don't.
Previously.
Who's here? I'm Brian Boatright.
Correct, and you're gonna close that one up too, right? 'Cause I don't want to do that one ever again.
Yes.
Brenda, is it me or is it hot in here?
No, it's hot today.
Oh, yeah, the robe is going to have to go. Sorry, everyone, but it is like extremely hot. I thought I was gonna pass
Why
out.
would I do
Brenda.
that? Why would I do that?
Court is calling 2022 CR 5305, State of Texas versus Brian Boatright.
Yes.
Can I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
Hector Garza Jr.
And are you Mr. Boatright?
Yes, Your Honor.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yeah,
Court will find that the state is in compliance with discovery. Mr. Boatright, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right, I'm gonna need you to speak up, Mr. Boatright.
Yes,
okay?
Your Honor.
Counsel, do you waive the reading of the indictment?
We waive.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Boatright, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Do you understand you're charged with theft under $2,500 enhanced as a state jail felony? The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I feel that he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I feel that he is and was.
Mr. Boatright, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, your punishment is to be assessed at 180 days in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes,
State?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
none.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Judge. State offers states exhibit 1 and all attachments.
No objection from the defense.
Mr. Boatright, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you
Yes.
understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
Nothing.
All right, Mr. Boatright, it appears that you continue to steal. Why are you continuing to steal?
Well, I think mostly-
Everyone, please whisper.
I think mostly have a drinking problem. And I don't do it unless I'm intoxicated. I didn't really even remember this incident
but I finally pieced it together more or less. And I feel bad that I didn't show up in court. That's what I feel bad about. And I really
Okay, I
realized,
can't hear you. I'm sorry.
well, I realized that I didn't take care of business, and I didn't stay off alcohol for one thing. And I was living on the street, and I ended up while I was drinking, did some stuff I didn't plan on doing. I don't remember all of this incident, but I'm sure it wasn't good, you know.
So how old are you?
I'm 67.
Do you have children, grandchildren?
No, I don't.
Do you have any family?
Yeah, I have some nephews and nieces.
Sisters, brothers?
Yes, I have a brother. I don't get along with. We just kind of leave each other alone.
Is this because of the alcohol?
It's a lot of things. That and just difference in lifestyle and different history, and we just don't. I think the nicest thing I can do is leave him alone. I guess we both feel, the same.
And do you have mom, dad?
No, they're passed away.
All right.
But that's I guess I got to the point on the streets where it was like a survival mentality, but I don't like this either any more than anyone else does. Can't let people do that. It's counter to everything that we know to be right, and so
Everyone needs to whisper.
I swear off of it, but when I can't handle alcohol, when I drink, I think
Well, here's the thing. I don't think your mom or your dad would appreciate the fact that you and your brothers don't get along. That's usually the one rule that parents have, that if they're no longer here, they would hope that the siblings would be able to watch out for each other. Now you're in your 60s, and I can say this because I'm in the same boat that you are. I have more of my life behind me than in front of me. But at some point, if you continue on the path that you're continuing on, you're going to be the person at the prison that everybody speaks to figure out how things are run.
Right.
Whenever you watch the prison movies, there's always the old guy there who's been there for all his life.
Prison sage.
Yes, and yes, that's it, the prison sage. And you're institutionalized. You can't live outside in the public anymore, and people come to you, and you know how the prison is run, you know how to get the laundry done and all of that. Don't end up being that person. You still have time in your life left where, who knows, maybe you can make up with your brother, but you've got to stop the stealing.
Right. Yeah, that's true.
You may end up in another court on another theft case, and guess what? This may not be your attorney, this may not be the prosecutor, and I may not be the judge, and they may not follow this plea bargain agreement. You understand?
Right.
So what are your plans for after you get out?
Well, hopefully I'm gonna get all my identification together, and I can finish doing that at Hayes. Hope I don't get it all done in state jail. They do that. There's social worker there.
Yes.
People to do that. It's just at the time factor, and I can get part of it done, get the rest done on the outside.
All right. And so immediately when you get out, you need to go to some NA meeting or something. You understand?
Yeah.
All right. I'm going to follow your agreement. Finding you guilty, I'm going to send you to 180 days in the state jail facility. I'm going to ask for the therapeutic community. I can't order you to take that. I don't have any jurisdiction to force them to place you in it. But if you request it and they think you're appropriate, they'll place you in it. It will not increase the length of your sentence at all, okay? But it will help you make contact when you are released to different programs that can help you with your alcohol problem. And I'll give you credit for any time served. Is there anything else from either side with regards to sentencing?
Nothing.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. Don't be that person who looks up, your brother has passed and you all are still holding on to whatever you're holding on to. Okay?
Okay, thank you.
All right, good luck.
Appreciate it.
You're welcome. Who is on Rico Fernandez?
Agular.
I don't have the file.
That's what I was.
All right. Who's here on Rico Fernandez? All right. All right, the court is calling 2022 CR 5385 and 2022 CR 5386, State of Texas versus Rico Fernandez. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Guillermo Lara for Rico Fernandez, Your Honor.
And are you Rico Fernandez?
Yes, Your Honor.
Counsel, in each of the cause numbers, I'm showing you the discovery acknowledgement. Have you received all of the discovery in each of these cause numbers?
I have, Your Honor.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Fernandez, in each of the cause numbers, I'm showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Correct, Your Honor.
I'm sorry?
Correct, Your Honor. Yes, ma'am.
No, that's either yes or no.
Yes.
All right.
Yes.
I'm going to show you what's entitled a true bill of indictment in each of the cause numbers. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment in each of the cause numbers?
Yes, sir.
Stating cause number 2022 CR 5385, are you proceeding on the indictment as presented?
Yes, Judge.
And cause number 2022 CR 5386, are you proceeding on the indictment as presented?
No, Judge, we're proceeding on count one, waiving count two.
Any objection?
I'm sorry, Judge, proceeding on count two, waiving count one. I'm sorry.
Okay. Any objection?
No, Your Honor.
Mr. Fernandez, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? And did you sign it in all the appropriate places?
Yes, I.
And cause number 2022 CR 5385, you're charged with the offense of felon in possession of a firearm. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
And cause number 2022 CR 5386, the state is proceeding on count 2, which is possession of a controlled substance, penalty group 2, 4 grams to 400 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
And each of the cause numbers, did you understand if you have a plea bargain agreement, the state does not have to follow your plea bargain agreement? If for any reason, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement, you can withdraw your plea. The fact that you entered a plea will not be used against you. And did you understand?
Yes, Your Honor.
And each of the cause numbers, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering the plea bargain agreement in each of these cause numbers, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
All right, one moment. The temperature is now back to a reasonable level. Before it was like so hot. All right, Mr. Fernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear?
No,
Has anyone promised you anything other than the plea bargain agreement?
no, Your Honor.
Are you satisfied with the way you've been represented?
I am, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement in each cause number, punishment is to be assessed at 6 years in the prison. There's $1,000 fine. There's no application for deferred adjudication. State recommends community supervision. The cases will run concurrently. The state will take in consideration 2022 CR 5361 and 2022 CR 5384. There is an agreed order to forfeit and destroy all seized weapons. And there's $171 to SAPD for drug testing. Is that $171 to be in each cause?
Judge, I just put duplicate conditions, but we can just put it on the drug case, which is 5386.
And then in cause number 2022 CR 5386, the state is proceeding on count 2. Mr. Fernandez, did you understand that to be the plea bargain agreement in each of the cause numbers?
Yes, Your Honor.
Defense is at the plea,
Yes, Your Honor.
state is at the plea.
Yes, Judge.
And each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement and in each of the cause numbers. The state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I do, Your Honor.
Then in cause number 2022 CR 5385, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2022 CR 5386, how do you plead to count 2? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, there are for states exhibit 1 and its attachments to the case.
No objections, Your Honor.
Mr. Fernandez, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachment in each cause number, the court will find there's sufficient evidence to find you guilty. And each of the cause numbers, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. Judge, at the time, Mr. Rico Fernandez, at the time, Judge, understands specifically what he did wrong. And again, what is illegal and what is not legal here in Texas, whether or not something may be legal in another state, he understands that. The court will not have any issues with him. Again, I've spoken with him at length about that. As far as the other issue with the firearm in the vehicle, Judge, it wasn't oversight. He knows that he should not be around firearms, whether or not he's driving a vehicle that belongs to someone else, whether or not it's his vehicle and someone has a firearm. He is
Whether or
not.
not he's driving without a license?
Right, Judge. Either one of those issues, he understands he cannot be doing those things because of the fact that he's going to end up right here before the court again. He's just asking this court for an opportunity. He has a 2-year-old daughter. Judge, earlier I mentioned that it was a 6-year-old. I misunderstood him on the phone. He said she's sick, not that she was 6.
Okay.
And that's why she was out here with him, Your Honor. He does want this court to just understand that he is working over 40 hours a week at Hollingsworth. It's hard labor, but he understands that that's what he needs to do in order to make things right and to earn an honest living. He's just asking this court for an opportunity to be on probation and to continue to provide for his family, Judge.
All right, why are you driving without a license?
Your Honor, procrastination is the issue on that one. I am setting forth contacting the courts.
Well, I mean, there's no confusion about the fact that you cannot drive without a license, is there?
No, ma'am, there's no.
And isn't that the case in every state?
That is, yes, ma'am.
All right, so there's no confusion about that.
No, ma'am, there's not.
And you know you're not allowed to have any weapons, right?
I do, ma'am.
And so you have a 2-year-old. And who's taking care of the 2-year-old?
Me and my lady, I would say it's our firstborn. It's a little rough right now on both edges. So
What's her date of birth?
12/02. I'm sorry, 12/02/20. She's born on December 2nd.
All right, so
Yes, ma'am.
let me just tell you what my concerns are. My concerns are you have a 2-year-old and you still did this. Right?
Yes, it is a
And
concern.
if you're drug tested, what are the results going to be? And know that you will get drug tested today.
It would be marijuana, ma'am.
All right, so people always come before me and act like they're being the very best parent for their child, and they're not. Smoking marijuana, and I don't care what anybody says, if you smoke marijuana and you're around a child, that child is going to be smelling that marijuana. I don't smoke cigarettes, never have. It smells horrible and it messes with my allergies. And I guarantee you, if I'm around someone who has smoked cigarettes, then guess what? I end up sneezing. It's not good for me. And my immune system is top notch. Your 2-year-old, the fact that she's sick, you know what that means? Her immune system is not top notch, and you're bringing things in her life that should not be in her life. And just as a side note, people, please stop smoking around entrances because nobody wants to walk through in your cloud of smoke. So even though you're not allowed to smoke in the building, just hanging around the entrances to smoke there when people got to pass through, it's a little bit disrespectful to us who don't smoke and who have bad allergies. So other than smoking marijuana and making things worse for your child, what have you been doing with your life?
Really, I've been just staying focused on walking the straight and narrow, just working, making an honest living.
Other than smoking marijuana?
Yes, ma'am. Yes, ma'am. I do have intentions on furthering a career with other ambitions that I've been working on for a while now. It's just being in the debacle of the wrong choices and the wrong crowd. You know, just moving forward has been somewhat of a challenge up until this point, with my daughter being in the midst of all of this environment. And I do understand there's no excuse. And I've just been making the changes a day at a time. I am a human being. That's all I have to say on.
All right, well, you had me at wrong choices, but then you took me on the side street by saying wrong crowd. Let me tell you how I feel about the wrong crowd thing. if there were someone else before me, they would say wrong crowd. And I would be like, oh, who's the wrong crowd? And you know what name they give me your name. So when people are in a wrong crowd, they're part of that group. So if that's the wrong crowd, then you're the wrong crowd. Okay. All right. When's the last time you used marijuana?
A few weeks, about 2-3 weeks ago, Your Honor.
See, and your daughter needs you to be there 100%. For her, she doesn't need the fogginess of marijuana clouding her life. And then guess what? Your daughter goes to daycare, people will smell marijuana on her. Or when your daughter gets older and she goes to school, sometimes children can be mean. Sometimes children don't have a filter. And they're going to be saying that she lives at a marijuana house. No child asked to be given specific parents, but you decided that you wanted a child, you have a child, and you've got to give her the best chance she has to be successful and have a great upbringing. And you're starting off on the negative. And the fact that you're with her mom and her mom is tolerating this marijuana means she's not getting it from her mom either.
No, ma'am, we're separated at the time. We're separated at the moment.
Well, that may be a good thing, right? You need to get your life together.
Yes, ma'am, I understand.
All right, this is what the court is going to do in cause number 2022 CR 5385. The court is going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's $1,000 fine that will be probated. This is run concurrent with 2022 CR 5386. Take in consideration 2022 CR 5361, 2022 CR 5384. The weapons are to be forfeited. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to want parenting classes. And that could be with Triple T. And once you complete parenting classes, the remaining of your community service hours will be waived. I'm going to want him tested for levels. And those marijuana levels need to be going down. You understand?
Yes, Your Honor.
And after he tests negative, then I'm going to want random UAs until further notice. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. And there's to be no unsupervised contact with minors until you provide a negative UA. You understand?
Correct.
So if you love your child, you will make sure that you don't use any drugs and you get a negative UA. You understand?
Yes, ma'am.
I'm going to want field visits 2 times per month. And that will be until further notice. Probation, does he need anything else?
Regular reporting, Zoom or?
Regular reporting can be Zoom or in person. All right, anything else probation?
No, Your Honor.
All right, on that probation, Mr. Fernandez, is there anything else you need from the court in order to be successful?
I know, ma'am. If there are any questions, I will contact Mr. Zavala.
All right, and that cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. In 2022 CR 5386, the court is going to sentence you. And of course, the court found you guilty. The court is going to sentence you to 6 years in prison suspended and probated for 6 years. Again, there's a $1,000 fine that will be probated. This will run concurrent with 2022 CR 5385. There's $171 to SAPD for testing. Weapons are to be destroyed and forfeited. $200 community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you get the COVID vaccination, but if you do, 40 of those hours will be waived. The remaining community service hours will be waived once you complete parenting classes with Triple T. Again, I'm going to want him tested for levels. Once he's negative, then it will be random UAs until further notice. Proof of employment within 15 days. There's to be no employment as a home healthcare provider or with minors. There's to be no unsupervised contact with minors until negative UA. Field visits 2 times per month until further notice, and regular reporting by Zoom or in person. With regards to that cause number, is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So here's the thing. This is your first child. Maybe you don't have experience with children, but I can tell you 2-year-olds and children, once they start walking, they get into everything. And they're just curious, so they explore. And you don't want a child exploring your house, getting into drugs, and then taking drugs and perhaps dying from that, because it would be your fault. You understand?
I do, Your Honor.
And you don't want a 2-year-old getting involved and getting into your guns and then killing themselves, and then it would be your fault. You understand?
Yes, ma'am.
All right, if there's nothing else, then you, probation will go over conditions with you. Good luck to you.
Thank you for your understanding.
You're welcome. All right, is Robert Bauer here?
He was.
All right, is he still upset over Oklahoma?
He's just generally upset about everything.
All right, who's here on Juan Aveles? All right, what is happening with this case?
Judge, we're still at a standstill.
Okay. All right, so have you all made sure that you have all of the discovery, the court?
We have, Judge, and I know that I've gotten some CPS records. I've executed a protective order on that, so I think we've got everything. Judge.
All right, could I have I don't have a discovery acknowledgement.
Yes, Judge. I know Michelle's extensively worked on this case. And
Okay,
should have it.
all right, so if I can get a discovery acknowledgement done,
I'll get that right.
and then I'll call you right back up. All right, thank you.
Judge, I've got Miss Pride up there as well. Let me see. Just I'll put you have it.
I'm sorry, who else do you have?
Courtney Pride.
Courtney Pride? Courtney Pride.
Kind of.
Are you related to Charlie Pride? Okay, see, I'm the only person who know who Charlie Pride is. All right. Why are you late for court?
I'm sorry, I was just a little bit of traffic.
All right, so here's the thing, you gotta make plans for traffic. I don't tolerate people being late for court, so this is your one late time. What I can tell you though, if you want, I can make sure that you're on time for court, or at least we know where you are. You know how I do that? Go to jail, we bring you over, they will bring you over wearing either a blue uniform or red proof uniform, however they classify you, okay? So don't be late again. All right, so where are we on this case?
Judge, the state's still attempting to contact witnesses in this case. The defense did provide us evidence that we need to ask the complainants about in order to get their side of what happened.
All right, Norma, can I have a 30-day reset? All right, so we'll be back on November 9th, you said? All right, so we'll be back on November 9th. Francisco Aguilar. All right, where's Francisco Aguilar?
He might have stepped out to the left.
All right. John Anthony Robles.
We just worked at a big deal, so we're trying to pay for it.
Julianne Hughes.
Thank you, second.
All right. Mr. Hughes, just have a seat. I'll take you up just after this case. Francisco Aguilar. All right, so what is happening with this case? Where are we?
Judge, so there was some new evidence. There was a co-defendant in the case. And there was some evidence from the co-defendant file that was not in my client's file. So the DA just transferred all that over earlier this morning while we were looking at it.
All right, who's the co-defendant?
He's in the 437. We're working on getting it. We have the lower, so it should be transferred to us, Judge, so we're working on getting that done.
All right. And Norma, can you make sure that when that case comes from the 437, that these are placed on the same date?
Yeah.
So can I have a 30-day reset and it'll be for discovery? All right, so we'll be back on November 9th, and that's just for discovery.
Yes, ma'am.
All right, do you have any questions, Mr. Aguilar?
No, ma'am.
All right, Ms. Ferguson, we'll give you a reset form. We'll see you then.
Thank you.
Julianne Hughes or Julianne Hughes? All right. So where are we on this case?
Judge, he has a pending misdemeanor case, and I think if we get it resolved, it will resolve this case. I don't know when it's set, but I do want to discuss the offer being made with Mr. Hughes. I think it's likely going to resolve all the cases.
All right, so when is that?
I don't know, I should have looked it up.
All right, thank you.
Sometime in 2022 between now and the end of the year. I guess October.
Yes.
It is in this. Your court date, no?
The court date for that, they really haven't given anything.
Oh, we're gonna get you a court date before you go.
for
Who's
the-
County Court 12?
That is Yolanda House.
Okay, pardon?
October 14th.
Oh. So your court date is October 14th. Okay. See, I believe, Brenda, I'm a firm believer that everything happens for a reason and it's always for the best. The fact that they are resetting this, he now knows his court date is October 14th. Otherwise, you would not have shown. All right. So we're gonna put this date, Ms. Ferguson, can we put this on October 14th and we will see where you are in the misdemeanor court, but you can go to misdemeanor court first.
Would it be possible to set it a day after, because that case will resolve yours and it will lighten the load for everybody? Or
No, see, here's the thing, if you
Yes.
put it on, never, Brennan, what's the saying, never put off for tomorrow what you can do today?
Right.
So if he goes down to the 14th, and I'm giving you my permission to go to county court 12 first. Yes, you work that out, and then the state will let me know, and he won't even have to appear here. They will just hand me a dismissal. See how
6 and 1.
see how the system works?
6 in one, half dozen in the other.
There you go.
I like that one too, Brian. Okay, so 14th.
Yes, and Ms. Ferguson will give you a reset form, and Ms. Ferguson, make sure you put on the reset form that he has permission to be in 12 first, and I'll write that on the docket sheet.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
Just go ahead. You go outside. Joe. I'll get this.
Yeah.
All right, who is here on Christopher Reyes? John Christopher Reyes.
John Charles Buck,
All right,
John Christopher Reyes.
Charles, I needed you earlier this morning. You would probably be the only person in here who knows who Charlie Pride is.
Charlie Pride?
Yes,
I know Charlie Pride.
other people
God
do not
rest his
know.
soul.
Yes. All right, let me see where Mr. Reyes is on my docket sheet.
He's a special setting, he's a recall for asking the court to set a bond. And you had ordered a PR bond interview, not for the purpose of PR so much as for information for yourself.
Yes, and I have that. All right, thank you. So who is the prosecutor?
Anybody you want.
All right.
Mark
You
is
wanna-
pretty good.
All right, Mr. Sanders, you want to confer with Mr. Bach on a bond setting for Mr. Reyes? And if you all want to look over the PR bond information,
We
and
have
I
to.
just handed that to Mr.
All right, thank you,
Sanders.
Judge.
All right, just have a seat and we'll get to you.
Thank you.
You're welcome. All right, who's here on Juan Avalos? We've already done that, right?
Marcus, why
You need to get that discovery knowledge.
Okay, just,
Multi.
all right, the discovery acknowledgement has been signed. We have a jury trial that is ahead of your trial. So, Ms. Ferguson? I'm gonna put you sort of on standby, but I'm gonna give you a date. And if that child does not work out or that child trial falls through, then you'll be up, okay? All right, so, Ms. Ferguson, can I have a jury trial setting on Avalos? And you did say there was something new with discovery, or you have it?
Yeah, we have it all.
Okay.
So we've gotten CPS records, I've viewed the videos, he's gotten everything that there's off of it.
All right, so you don't need a plea deadline date extension with the jury trial?
No, Judge, I don't think so. Like I said, we've gotten it all. I've looked at it.
Okay, and Mr. Avalos, you want a jury trial?
Yes, ma'am.
Okay, so your plea deadline date has expired, so the court will not accept any plea bargain agreements in this case without good cause. Otherwise, if you decide to enter a plea, it have to be open to the court. Do you understand? Okay. Ms. Ferguson, I need a jury trial setting. Okay, what date? When? Okay, so it'll be 10:30 first. And you'll be an impact court. And that will be at 9 a.m.
We're good.
Okay, Ms. Ferguson will give you your reset form. All right, who's here on Sergio Martinez? How's your wife doing?
A lot better, Judge. Thank you.
Oh, that's great. And how's your brother doing?
Oh, it was marvelous.
Yeah. All right, court is calling 2022 CR 7495, State of Texas versus Sergio Martinez. Now parties announced for the record for the state,
Marcus Sanders.
for the defense.
Michael J. Sawyer.
And are you Sergio Martinez?
Yes, ma'am.
All right, Mr. Sorry, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding on paragraph B.
Yes. Any objection?
None, Your Honor.
Mr. Martinez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of burglary of a habitation force? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on paragraph B. Punishment is to be assessed at 5 years in the prison. The state is opposing your application. There's to be restitution to Teresa Sheets, SCHEETS, and no contact with Teresa Sheets. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such
They have
motions?
not.
Then to paragraph B in the indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, State Offer States Exhibit 1 and it's attached.
Defense has no objection.
Mr. Martinez, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
Even if I'm not.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. So is a TAP evaluation needed or no?
I think would be in order.
All right. So probation, there's to be a TAP evaluation and PSI. What date are we coming back, Ms. Ferguson?
We'll have one witness, Judge.
You have one witness. Okay. Will there be any witnesses for you, Mr. Sawyer?
At best, two.
All right. All right, so we'll be back on November 16th. Mr. Martinez, I'm going to base my decision on your application based upon the PSI report and any other evidence that's presented to me. All right, thank you.
All right, so I'll have the time being, my excuse.
Yes, you are. Thank you. Always a pleasure to see you. Have a good one. Are we all ready on Christopher Reyes?
Almost.
Okay,
Let me just confirm with my client real quick.
okay, sure.
Thank you. Okay.
Yes, Jose Rodriguez.
Yes, ma'am. Judge, apparently I was appointed recently, I think it's an NPR, but I received no notice other than a text message this morning, and so I was begged the court if I could maybe have a week.
All right, have you talked to Mr. Rodriguez?
I haven't again. I just got a text message this morning.
No, I understand, but he's here. Have a conversation with him since he's here, and then I'll consider your reset. So just have a conversation with him and at least show him the motion to revoke. And Norma, can you see where Michael Young is? So the attorneys we have remaining are Suzanne Kramer, Todd McCray, who's here, Monica Guerrero, Tony Jimenez. They're supposed to be back at 12. And then Joanne De Hoyos.
Monica's case for us is supposed to be approved.
All right, so I mean, paperwork needs to be turned in.
It's done. It's just we're waiting for it to come back.
Okay. So Norman, if you can let her know her paperwork is done. Thanks.
Judge,
Yes.
wanted to tell you, we had a coon a few weeks ago get into our chicken coop. The coon, whenever a coon does that, they'll kill every chicken, whether they're gonna eat them or not, they don't care. But, so I made a phone call to our chicken supplier. To get more chickens, they've gone up to $30 per chicken. I've never heard, I used to pay $5 a chicken.
Yeah.
So
Wow.
anyway, I just wanted you to know.
Well, are you gonna be protecting your chickens?
Well,
Well, I mean, because, come on.
yeah, you can. At this rate, you can bet on
Thank you.
it. Anyway,
John Christopher Reyes.
Yes, you're all ready?
We are.
All right, state John Christopher Reyes. And if I could see the PR bond, because that's the only copy I have.
I'm sorry.
Do y'all need another copy?
No,
Okay. And before we go on the record, is this just a bond for one case or for both cases?
There'll be two cases, Judge.
Okay. All right, court is calling 2022 CR 7468 and 2022 CR 7736. State of Texas versus Christopher John Reyes. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Charles Bunk for Mr. Reyes.
And are you Mr. Reyes?
Yes, sir. Yes, ma'am. Yes, ma'am.
All right, so we're back on these cases for the defense to request for the court to set a bond. The court ordered a PR bond evaluation to be done, although both parties are aware that based upon the defendant's charges that the court is not going to grant a PR bond. The court was using, everyone quiet, please. Court was using the PR bond evaluation to make sure that the court follows the rules that have been set down by the legislature with regards to setting of bonds, and the court is in receipt of that. Is there an agreement on a bond or no?
Yes, Judge.
All right, so what is the agreement?
The agreement is, well, I'll speak on behalf. The agreement is on the aggravated assault with a deadly weapon. The bond will be set at $75,000. There will be a global positioning satellite monitoring device with full house arrest at this time. And the bond on the drug case will be $10,000.
All right, state, is that the agreement?
Yes, Judge, and also there were previously
sorry,
no
no contact.
no contact.
And is that in both, the no contact in both cases?
On the ag assault. Judge.
And what is the no contact?
It is with Charles Wilhite, last name Wilhite, Warner Wilhite, and Jesus Baltazar, Baltazar.
BALTAZER?
ZAR.
ZAR, okay. All right. So is that the agreement?
It is, Judge, and I apologize. I didn't leave out the no contact on purpose. I forgot.
And so that the record is clear, the court is in receipt of the PR bond evaluation. And based upon my review of that, the court's finding is that the $75,000 bond and cause number 2022 CR 7736 with the full GPS is appropriate to safely protect the community and also ensure Mr. Reyes's appearance for court. And the court will find also in 2022 CR 7468 the same findings with regards to the $10,000. Is there anything else from either side?
Not at this time, Judge.
All right, so the court needs a B page on each of these cause numbers, or
Okay.
do you have the order or no?
I don't have the order. I filed something, but I don't have it with me. So
All right, so your next court date, Mr. Reyes, is going to be November 4th. Before you leave, let me give you a reset form. And so, Mr. Reyes, make sure you're back here at 9 a.m. on November 4th.
Thank you, Judge.
You're welcome.
Thank you for the details. Give you a copy. Now we'll leave it out. All right. Okay.
Yes. Oh, it was recalled because she didn't come back. So tell her it's coming back on tomorrow. If it needs to be there. Mr. Adame? Manuel Adame, come forward. All right, Mr. Adame, your attorney couldn't be here today, so we will see you tomorrow at 9 a.m.
Morning.
Yes, they'll give you a reset form. Thank you. Oh, this needs to be in the file with Reyes.
That's beautiful. If I have an agreement on an MGR to continue, do you require the certificate of appeal be signed anyway?
Yes.
Let me tell you.
It's the never ending story of the equipment in the one. Yeah.
I need to figure out it's discrepancy.
It's like always something with us.
Yeah.
Hopefully by the afternoon one.
Okay, so what about?
I don't want to be.
But did you order any kitchen?
Yes, that's the question.
I'll double check.
Door's locked.
Oh, and Norman, I mean, see if you can do something with the AC. Are you in charge
What
of the
about the
AC?
That's probably on.
Are you in charge of the AC? Can you?
We need to go through, did everything go through?
Oh, it's too hot.
It goes through her?
I'll give my.
All right, thank you. Tell them I think the heat is messing with the electronic equipment. All right, Donald Gillyland. Donald Gillyland, come forward. So we're here today for a plea.
Well, I was hoping we were. Last week when I was here, Mr. Groomer instructed me that this was the gentleman that I needed to talk about the case, come back. So we reset it for today. We're close, but we're not ready yet.
Your Honor, the issue is that in several of these cases, the amount of evidence, at least one goes over 400 pieces of evidence, and another one goes over 300. It's all different instances. They're not all from the same transaction.
Okay, so here's the court's issue. Is like this case has been set since 2020. And we're still going on. So, and then one of the cases is from January 2019. And then another case, yeah, January 19th. So cause number 2000, even though it says 2022, it's been going on since January 19th. All right, so these are being set for jury trial. So Ms. Ferguson, I have a jury trial date and a plea deadline date and each of these cause numbers for Mr. Gilliland.
If we are able to reach out a plea prior to those dates, can we ask Nelmer to bring him back at our earliest convenience?
He will only be brought back for a plea
If
if the paperwork has been completed. So y'all need to transfer that paperwork and y'all can do it by Zoom at the jail, but he's not being brought back over for a plea. That's not happening because we've been here on more than one occasions for a plea. All right, November 15th is going to be your jury trial date and plea deadline date. If you decide not to accept a plea on that date, you will be going to jury trial and the court will not consider any plea bargain agreements without good cause. Do you understand? That's yes or no?
He said yes.
Okay.
He's-
All right, we will see you then.
Thank you, Judge.
All right, you're welcome.
There's a hearing thing. Thank you. May I be excused, Judge?
Yes.
Thank you.
Here you go.
No, we're ready.
Mr. Gilliland. Okay, who's here on Mario Zavala?
I am Judge.
Court is calling 2021 CR 7277 State of Texas versus Mario Zavala. Could I have parties announced for the record for the state? For the
Dan
defense,
Kramer from Mr. Zavala.
and are you Mr. Zavala?
Yes, ma'am, I am.
All right, everyone needs to whisper in the box. Mr. Zavala, I'm showing you what's entitled motion to revoke community supervision and state's motion to supplement pending motion to revoke probation. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Mario Zavala who's placed on community supervision in 2021 CR 7277 for the offense of unauthorized use of a vehicle on October 19th, 2021 for a term of 2 years? Is that you?
Yes, ma'am, it is.
State?
Violated condition number 13 on or about 12th day of July 2022 in Bear County, Texas. The defendant, Mario Zavala, did then and there fail to complete 120 hours of community service restitution in violation of condition number 13.
How do you plead to that? True or not true?
True, ma'am.
Your Honor, the state waives all other violations.
Any objections?
No objection. Judge.
Mr. Zavala, did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion and sentence you to 180 days in the state jail facility and up to $1,000 fine? Did you understand?
Yes, ma'am, I do, considering that my probation.
Now,
was-
here's the thing. I'm
Okay.
asking you a question.
Yes, ma'am, yes, ma'am,
Let me just tell you this. Attorneys like for their clients to only answer the question that's being asked of them.
Okay, ma'am.
So, did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, sentence you up to 180 days in the state jail facility and up to $1,000 fine? Did you understand?
Yes, ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition 13?
Yes, ma'am.
Court will find violation of 13 true. Is there an agreement?
Yes, Your Honor, the agreement is for the defendant to be placed under mixed supervision on their caseload, and we are going to TIC his misdemeanor cause number 688567.
That is what we agreed to, Judge.
All right, Mr. Zavala, you're asking the court to follow that agreement?
Yes, ma'am, I do.
All right, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, I do.
All right, so what's going on in your life?
Well, it's pretty positive right now. I have just gotten my housing. I've been homeless and I have had an apartment for the past year. And I had just been granted my housing, which is a forever lease. So it's really gonna help me engage a better life. I'm not drinking, I'm not engaging in any drugs or anything. I'm doing very well to where I was before. So I think I deserve a chance to reconsider my probation.
But here's the thing, people always think they deserve another chance. Whether or not they deserve it, that's something completely different. Because people will argue that your chance you were given was being placed on probation.
Yes, ma'am.
So I'm trying to see where you are to see whether or not I'll follow the agreement that's been reached by your
Okay.
counsel, okay?
Yes, ma'am.
All right, so how much time does he have in custody?
Yes, 63 days, Judge.
Okay. Well. All right, so are you employed? Are you working? Do you have SSI? What's going
Yes,
on?
ma'am. I draw SSI. I'm disabled.
Okay. And you mentioned no alcohol or anything. Is there any other drug issues other than the alcohol?
No, ma'am. All I do is smoke cigarettes.
All right, that's not healthy.
Yes,
I
I
know people do it, but that's not healthy.
Yes, ma'am.
All right, so this is what the court is going to do. The court will deny the motion. Alternate man conditions to include Mick. Has he already been evaluated for Mick evaluation or no?
Yes, Your Honor.
All right, so we're going to place you on the Mick caseload, taking consideration 688, 563,
567.
567. So that's taken in consideration 688, 567. You were ordered to do 120 hours of community service restitution. I will give you what I give everyone else, which is if you take the COVID vaccination, which includes the booster, 40 of those hours will be deducted. I'm not requiring you to get the booster shot. That's completely up to you. And there's going to be proof of SSI within 15 days. And we're going to do sober meetings for him 1 time per week. And we'll do field visits 1 time per month. for 3 months. If there are no issues, then the field visits can be discontinued or taken as probation sees fit. All right, I'm doing the sober meetings 1 time per week, but here's the thing. You know you better than I know you, better than your attorney knows you, if you've done an introspection of yourself. So if you feel like you need sober meetings more than 1 time per week, then you can do that. It's not going to extend your probation at all. That will just be telling the court, you know what you need to do in order to remain clean and sober. You understand?
Yes, ma'am.
Probation, the key is staying in contact with your probation officer and communicating. If there are issues that crop up, let your probation officer know. They'll let me know. If there's an issue where you fall off the wagon, let probation know. They'll let me know and we'll see what we can do, okay?
Yes, ma'am.
All right, do you need help with anything else?
No, ma'am, I'm fine. Thank you.
All right, good luck to you.
Thank you, Judge. May we be excused?
Yes.
Thank you.
And Judge, here's the dismissal.
You're welcome. Who's here on John Anthony Robles? All right, the court is calling 2022 CR 8457, State of Texas versus John Anthony Robles. Can I have parties announced for the record for the state, for the defense?
Officer Cepeda from Mr. Robles.
And are you Mr. Robles?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Robles, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor. We waive.
State, are you proceeding on the indictment as presented?
Judge, we're waiving the repeat offender enhancement paragraph.
Any objections?
No objection, Your Honor.
All right, Mr. Robles, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right. What you're charged with is evading arrest. And I'm sorry, did you sign it in all the appropriate places?
Yes, Your Honor.
All right, what your charge is evading arrest, detention, second or more as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Robles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 180 days in the state jail facility. There are no applications. The state will take in consideration 686,448. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
And state offer states exhibit 1 and its attachments.
No objections, Your Honor.
Mr. Robles, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, other than to follow the agreement, Your Honor.
All right, Mr. Robles, the court will follow your plea as previously stated. The court is finding you guilty. The court will sentence you to 180 days in the state jail facility, give you credit for any time served, taking consideration county court cause number 686-448. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Robles, here's the thing. Your criminal history does not look good. I'm going to tell you what I tell everybody who comes here. You may end up with another case. It may be a different attorney, it may be a different defense attorney, different judge, and you may find yourself doing hard prison time. And I say that even though I know any prison time is hard. I know people will say, oh, a person can do this, they can do that. But until you've actually been to prison and done real time at the prison, we can only speculate. So how old are you?
33.
All right, so you still have more of your life in front of you than behind you. But if you continue on the path that you're on, your life may not be long because of the dangerous things that are happening in your life, okay? Do you have children?
I don't. Yes.
All right, well, don't have children yet until you do an internal inspection of yourself and get your life together, okay?
Thank you, Your Honor.
All right, you're welcome. Have a good one.
Appreciate it.
You're
Yeah,
welcome.
you too.
Who's-
Excuse, Your Honor.
Yes, who is here on Jose Rodriguez?
Oh, I'm present on him, Your Honor.
All right, come forward. All right. Are you ready to proceed on
Ready.
this? All right, the court is calling 2019 CR 2508 State of Texas versus Jose Catarina Rodriguez Jr. Could I have parties announced for the record for the state?
Catherine Pollard.
For the defense?
Morning, I am Todd McCray for Jose Rodriguez.
And are you Mr. Rodriguez? Mr. Rodriguez, I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review that document with your attorney? Did you understand it? Are you the same Jose Catarino Rodriguez Jr. who's placed on deferred adjudication in 2019 CR 2508 for the offense of assault, bodily injury, married cohabitation on January 16, 2020 for a period of 2 years and extended for a period of 1 year? Is that you?
Yes, Your Honor.
All right, state.
Judge, it's a violation of condition number 5 in Bexar County, Texas. The defendant, Jose Catarino Rodriguez Jr., did then and there fail to report to the supervision officer as directed for the months of May and June 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Judge, we would waive and abandon the remaining counts.
Any objections to the state's waivers?
No objection.
Did you understand by pleading true to violation of condition? Just one moment, I'm sorry.
It's a class A misdemeanor.
No, I know it's a class A misdemeanor. I'm reading the plea bargain agreement. And I'm trying to figure out if he is supposed to be on deferred adjudication or not, because I'm reading the plea bargain page, and the plea bargaining page was punishment be assessed at 210 days in jail. So let me just see
We had. the
what I
same-
wrote on the docket sheet.
We had the same question. Your Honor.
Okay.
We saw the order deferred.
Okay. Oh, yeah. So I guess what I did is I placed you on deferred adjudication. Because the court felt that 210 days, you wouldn't learn anything from that. All right. So did you understand by pleading true to violation condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand? Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
All right. Is there an agreement?
Yes, Judge, we would ask you grant the state's motion to enter the adjudication of guilt and revoke the community supervision sentence into 131 days in the Bexar County Jail. Credit for time served, the affirmative finding of family violence, and we would ask that the judgment be satisfied.
All right. So here's the question. Why should I give him 131 days in jail?
Judge, he's here with his family, Maricela Rodriguez, will you stand up? And Maria Aguilera, you stand up. That's his mother and his sister. You can see that Mr. Rodriguez has been turning in some positives for marijuana.
Mhm.
And I asked him about that, Your Honor, and not providing erase samples. And he tells me at 33 years old, he was working for a roofing company. And he was placing work ahead of probation conditions. And he was really, that was a wrong priority arrangement. He realizes that. He was wanting the money for his family. That circumstance has changed now, Your Honor. He tells me that he would have work with his mother remodeling. So he wouldn't have that pressure of feeling like he needed to do whatever his employer told him. I believe he's learned his lesson. He's been on this a long time. We would ask the court respectfully for the 131 days. You can see here, he's humbly before the court. And I believe the court won't see him again. He's here with his family, so he does have the family support.
All right. Did he complete his GED? Probation?
Let me double check.
He was supposed to do either 80 hours community service restitution, or either he was to complete a GED or get a certificate from some sort of trade school.
I don't show a certificate of completion for that, Your Honor.
All right. Did he complete any parenting classes?
So we have a enrollment form, but we don't have a certificate of completion.
And I see where you came back because there were contested hearings scheduled in 2020. Then you came back in 2021 and the court ordered weekly Zoom reporting until further notice, which to me, that shouldn't have been difficult to do because you can report from anywhere. It's by Zoom. And then there was a UA and they were supposed to test for levels. I'm going to tell you right now, I'm not following this agreement. I'm continuing you and you're going to give me my community service hours. You're going to do parenting classes and you're going to report. Do you understand?
Yes, ma'am.
So I'm going to deny the motion. I'm going to alter and amend conditions. And there's going to be 100 hours of community service restitution. And that you're going to give me my parenting classes. and you're doing the 100 hours of community service. I've already tried where you complete your parenting classes and you don't have to do community service hours. That's not working for you. So you're going to give me 100 hours of community service restitution and you're giving me parenting classes. Do you understand? And there's going to be regular reporting by Zoom or in person. There's going to be proof of employment within 14 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Random UAs. And I'm going to want field visits 2 times per month until further notice. And I have on here CPS compliance. Was CPS involved? Child Protective Services?
I think you
Said that CPS should have been involved. So was CPS ever involved or no?
Yes.
All right, CPS compliance, if applicable. All right, is there anything else you need so that you can be successful on this probation? All right, and so probation, he needs to start doing community service hours every week. And there is to be a minimum of at least 3 hours a week. And if there's not a minimum of at least 3 hours a week, a motion to revoke will be filed. You understand? You are going to report. If you miss reporting, a motion to revoke is going to be filed. You're going to do random UAs. If you test positive, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
And are you going to be living with your mom?
For now, yes.
Defendant is to reside. Mom, do you want him living with you?
Yeah.
All right, defendant is to reside with defendant's mother. And you're going to provide that address to probation until further notice. So when you leave, I'll make that decision. How old are you?
33.
All right, you're 33. In the legal world, you're an adult, but you're living with your mom. So when you stay with your mom, you're not an adult in her household. So if she tells you lights out at 10, lights out at 10. If she wants you in the house by 10, you need to be in by 10. Do you understand?
Yes.
All right. Is there anything else?
Nothing further.
Okay. Yes.
I just wanted to make sure you're aware that he does expire in January.
Let me see how long he's been on.
January 2020.
So he expires in 2023. That's an issue. All right, so this is what we're going to do. We're going to keep the orders that I put in place, and we're going to have him come back December. I want to see that he's actually done something. And let's have him come back on December 16th. And Mr. McCray, I'm going to want you to stay on that on December 16th to see where Mr. Rodriguez is. All right, if there's nothing else.
The excuse, Your Honor.
Yes. Who's here on Ricky Martianson Smith? All right, Mr. Smith? And come forward. All right, the court is calling 2022 CR 6943, State of Texas versus Ricky Smith. Could I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Brent Hardy for the defendant.
Are you Mr. Smith?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smith, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I understood.
Counsel, do you weigh the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Smith, I'm showing you what's entitled Court's admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, Mr. Hardy, the fact that
I'm
you
sorry, Judge.
entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Did I want to do a plea in this case?
Yes.
Yes, ma'am, I did.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear?
No, ma'am.
To get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. The state will take into consideration County Court Cause number 682040. There's a motion to destroy the firearm, which is a Remington 33, no serial number listed. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge, but I'd like to address the court with respect to firearm.
All right, state, is that the plea?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that document? I mean, that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence.
Yes, Judge. State offers states exhibit 1 and all attachments.
No objection.
Mr. Smith, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty or proceeding with sentencing.
Yes, Your Honor.
All right, you wanted to say something with regards to the weapon, counsel?
Judge, I was only going to ask that instead of being destroyed, the weapon be turned over to defense counsel as compensation for attorneys.
All right. So I'm going to deny that. It states here that Remington does not have a serial number listed.
Oh, really?
Yes, that's what it states on the plea.
Sorry, there's no serial number.
Oh, I didn't realize that. Okay. Thank you, Judge.
You're welcome. So the motion to destroy firearm is granted. All right, so as previously stated, the court is finding you guilty, sentence you to 2 years in the prison, give you credit for any time served. Taking consideration County Court Cause number 682040, and the motion to destroy the firearm is granted. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. We can go off the record. How old are you?
I'm 21, ma'am.
All right, so you're 21. You're living your life footloose and fancy free. That's gonna have to stop. Because this whole little thing that you and the other people who are with you were doing could have easily resulted in someone being killed. You understand? Now, if you didn't know before, you know now, you're not allowed to possess any firearms. Do you have any siblings?
Yes, ma'am. I have 4 brothers and my mom,
All right, and are your siblings, are you the oldest or the youngest?
second oldest.
Second oldest? So you're supposed to be setting an example for those who are younger than you. You're not doing well. You understand? And you're breaking your mom's heart. All right, you understand? So now your mom is either gonna have to go and visit you in prison or call you in prison, and your siblings are gonna know you're in prison. You gotta start doing better. Life is simple. Stop making it so hard. Get a job. Go to school if you want to go to school. But stop with this nonsense. You understand? All right, good luck to you.
That's right. Thank you, Judge. May I be excused?
Yes. Who's here on Jonathan Mendiola?
That's me, Judge. Mine's up here, but my understanding is that it's not shipped in today.
All right, Ms. Ferguson, has there already been a warrant issued for Mr. Mendiola? Okay. Norman, can you just give this a 60-day reset then?
Very good. May I be excused?
Oh, just a minute. She's gonna give me a date. And I'm just putting a date down so he doesn't get lost in the system if he is picked up or turns himself in.
Okay.
All right, so it'll be December 13th.
Very good. Thank you, Judge.
You're welcome. Who's here on Angel Rodriguez?
I'm present, Your Honor.
Thank you. Court is calling 2022 CR 4503, State of Texas versus Angel Rodriguez. Can I have parties announced for the record for the state?
Catherine Pollard.
For the defense?
Monica Guerrero for Mr. Rodriguez, Your Honor, and he's present as well.
And are you Angel Rodriguez?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I received whatever the state has in their file, and I have reviewed this with my client.
All right, the court will find that the state is in compliance with discovery. Mr. Rodriguez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Rodriguez, I'm going to show you, and Norma, on this one, we need a PSI date. Mr. Rodriguez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation with intent to commit assault? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, The fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty, not grant you community supervision, and sentence you up to 20 years in prison. Did you understand?
Yes,
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishments to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. State is opposing your application for community supervision or deferred adjudication. They will take in consideration 2022 CR 1177 and grand jury number 779652. There's an affirmative finding of family violence and no contact with Mallory Salazar, Mallorie. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, we would offer what's been marked as State's Exhibit 1.
No objection, Your Honor.
Mr. Rodriguez, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and after reviewing the same, the court finds there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Ms. Ferguson, which date are we coming back for sentencing? All right. Is there a need for a TAP evaluation?
There shouldn't be.
All right. So probation, it'll be a PSI, full, but no TAP. We're going to come back on November 9th. At that time, I'll make a decision on your application for deferred adjudication. My decision will, of course, be based upon the stipulations, but also upon the PSI report and any other evidence that's presented to the court. Do you understand?
Yes, ma'am.
All right, thank you.
Judge, you would like to ask that you set a bond on the second case that's being dismissed.
All right, Ms. Ferguson, can you have a PR bond report done? And then I'll make a decision on that based upon that. And once that's completed, just contact Ms. Ferguson and she'll set it.
Thank you, Your Honor.
You're welcome.
Yes,
Yes, just give me 1 second. Let me find him on the document.
I'm sorry.
Yes, you may be excused. Okay. Yes.
Judge, I have an agreement with Brian on a bond setting. I had come by yesterday, he had me confer with Brian.
Mhm.
I just want to see if you'd sign off on that.
Okay.
I have a copy of the MTR if you want to look at it.
Yes.
Weed and 2 missed reports. Kind of taking the satellite off.
All right, who's here on Paniagua?
Yes, Your Honor.
I know I'm mispronouncing it. I'm so sorry.
I mispronounced it myself.
Okay, then I feel better. It's always great to see you.
See you, Judge.
All right, court is calling 2022 CR 3922, State of Texas versus Johnny Paniagua. Paniagua.
yeah.
Can I have parties announced for the record for the state,
Marcus Sanders,
for the defense?
Tony Jimenez.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, and we did, Your Honor.
Court will find that the state is in compliant with discovery. Sir, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding on count one, waiving count two and the enhancement paragraph.
Any objections?
None.
Sir, I'm showing you, see, I don't pronounce your last name. I just say sir. I'm sorry. I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Off the record, I'm going to give you the PSI date for this. We're back on the record. Did you understand you're charged with possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams? That's a first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count 1. Punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application for community supervision or deferred adjudication. They will take in consideration 2022 CR 6572. And there's $171 to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1 in an indictment, how do you plead guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, state offers states exhibit 1 and its attachments.
No objection.
Sir, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. When are we coming back for sentencing? All right, we're gonna come back for sentencing on November 10th. Defense, is there a need for a TAP evaluation?
I believe so.
All right, so there'll be a TAP evaluation and a PSI report. On November 10th, I'll make a decision on your application based upon, of course, the stipulations, the PSI report and any other evidence that's presented. You understand?
Yes, ma'am.
All right, thank you.
Thank you, Judge. May we
Thank you.
please speak?
Yes, probation, he needs to get his reset form and then probation will let him know what he needs to do.
Yes, Your Honor.
All right, Norma, what is he's talking with that. Okay. Okay. All right, thank you. So how many cases? We just have 2 left, right?
Yes, ma'am.
Okay.
Judge John.
Yes. Yes.
Judge, you asked me to approach you on this. I understand it's pretty late.
Oh, no, here's the thing
Two
on
years.
vouchers, when they're late. I know they will put 0 because it's late, but I always just tell attorneys, if you provide me with a letter for the reason for it's late, then if it's a flat fee, then I will consider just signing it.
That's great.
Yeah, sure. So we just do
Do I
that.
address it to you then?
Sure,
court?
yes.
Okay.
Yes, and if you want to write it out here, you're more than welcome to.
I gotta know what I was doing on it. Thank you, Judge.
You're welcome. Yes. Yes. Mhm. Find out what it is in the system. And then prosecute on that. No, he was, but of course, with the appeal, and the way it is, they're just refiling it. Yes. No, it's not an empty. Let me see the file on that.
The picture.
But in fact, after Valentine had a attorney as Mr. Gillyland.
No, Patrick Valentine needs to come back. So have Patrick Valentine and his client come back tomorrow so we can make sure that this is done. Because Patrick Valentine said that he was staying on the matter. Yeah,
So do we put Patrick on the main, as the main attorney on?
yes.
Okay.
All right, so
Because whoever
have them
created it,
come back tomorrow.
just that's the way it was.
Okay.
I'll explain to you.
So have Patrick and his client come tomorrow.
Okay, I'll contact.
All right, thanks. All right, and then Mr. Stateson, you said you wanted to approach on Monreal?
Yeah, there's a discovery disc that the state has. They're gonna verify that what's on it, whether it has or has not been provided to Ms. Doyle's.
Okay,
And if we could just have another second to continue talking about the plea.
all right. Ms. Ferguson, I need a 30-day reset on Monreal.
Judge, just so you're aware, the state is also going to contact the complainants in these cases.
Okay.
The discs he's talking about, it's just two discs that really don't have much on them to tell us what the memo, so
Okay.
we have to check.
All right, so we'll come back on November 9th.
Thanks, Judge.
All right, thank you. And Mr. Stateson on Monreal, if you all want to come back sooner than that, or you have information sooner than that, just let Ms. Ferguson know.
Yes, Judge.
Thank you for your help.
I'm finished with Monreal.
All right, court is going to call 2022 CR 7737B, State of Texas versus Sarah Lara. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Attorney of record is Joanne De Hoyos. Joseph Statesman standing in, and Miss Laura, would you give the judge permission for me to play in place of Joanne De Hoyos?
Right, so you're gonna have to make sure you speak up, okay?
Yeah.
And are you Sarah Lara?
Yes.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Laura, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state's proceeding on count 1 and waiving count 2.
Any objection?
No objection.
All right, Ms. Laura, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of credit card, debit card abuse and the state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her? Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Laura, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count 1. Punishment is to be assessed at 1 year in the state jail facility. There's $1,000 fine. There's no application for community supervision. There's no application for deferred adjudication. The state recommends community supervision. This is run concurrent with 685703. There's restitution to Austin Galan, Galan. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be 120 hours of community service restitution and no contact with Austin Galan and Cats 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No, contest.
State, any evidence?
Yes, Your Honor. State offers states exhibit 1 in all attachments.
No objection.
All right, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Judge, I ask that you follow the 3-year recommendation. And I did wish to add that Ms. Laura does wish to have some type of referral to Texas Workforce Commission. She's not employed. She hasn't been employed the last 2 years. And she's asking for some type of guidance with that. She has done many line assembly type of work before, but I don't want to set her up for failure. If, maybe part of the fine can be partially probated to help her out.
Okay, why are you stealing?
I have no excuses. I just thought I could get away with it, to be honest.
It's a bold move to take somebody's credit card and their debit card and go to Walmart, going to the dollar store.
I didn't do all of that stuff. That wasn't on me. I just did the storage.
Well, it's still theft.
Yes, ma'am, I understand that.
And so in order for somebody to have used this, you would have to have given it to them as well to use. And y'all both are using, here's the thing, you and this phantom person, y'all are both using credit cards and debit cards that don't belong to you.
Yes, ma'am.
So instead of stealing from somebody and using their credit card and debit card, get a job. And guess what? If you don't have a job, you don't steal from people and then use their cards to support your lifestyle. There are plenty of signs around. I'm going to give you, whatever workforce availability probation has, but I don't understand why people act like it's mysterious for you to see a sign that says workers needed to go in there and apply. How old are you?
40.
So it's not like you're some teenager who's never had employment before. Hopefully you've worked in your life.
Yes.
So you see a sign that says workers needed, you go in. And guess what? If you really are an upstanding citizen, even when you don't see a sign, you still will just go in and say, hey, I'm looking for employment. Is there any work available here? Can I apply? Do you have children?
Yes, I do.
And what are their ages?
My youngest is 13.
And where are they?
They're with their father.
And what's the ages of your other children?
I have a 14, 15-year-old, 21-year-old, the 25-year-old, and the 26-year-old.
And where are all of these children?
My 26-year-old lives in Houston. My 25-year-old lives here. She has children. And my 21-year-old lives in San Marcos. She goes to college out there.
All right, and your other children?
They're with their father.
Has Child Protective Services been involved in your life?
Previously, but
For what?
Me and my ex had an abusive, like a real toxic relationship, and it was.
What year was that?
That was in 2012, I think. It's been years ago.
And where are you planning on living?
I'm currently in a relationship and we have a house
In a relationship with
my current boyfriend.
who's not the father of your children?
No.
Are you able to take child support?
Yes, I am. I haven't had support, but I have gotten.
So basically, you're just having children and somebody else is taking care of them
Well,
and you're moving on.
I was with them just up until about 3.5 years ago. I was a full-time mom. I took care of them all of them
But you're moving on with your life in a new relationship and he's taking care of the children.
because he threw me out. It was a very abusive relationship.
Well,
And he,
you know what? Here's the thing. I understand people being in abusive relationships, but let me just tell you. Is it anyone's fault that they're abused? No. But you need to start taking stock of who you are and work on yourself before you just go from one relationship to the next relationship and you don't have employment. So that means that whoever you're in a relationship with, you're going to be dependent on them to support you financially. And you're depending on them to put a roof over your head. So while you have someone who has your children, which I don't understand if this person has your children and if that was an abusive relationship, maybe your children should not be with him.
If I have the means to, I would fight it. I'm still scared of him.
No, they have legal aid. They have all different services for that. And see, right now, I think you are running a con on me. And let me just tell you why. Because you're charged with credit and debit card abuse. And I see that when the police arrested you, you blamed it on your twin sister.
I did.
And they looked and they said,
no, I didn't. I don't even have a sister.
They said, I researched the actor's twin.
No, I don't.
And she was in federal custody throughout the duration of the time to include the day and fraudulent purchases were made.
I never claimed to have a sister. I don't have a sister.
Okay, I'm going by what's in the police report.
I've never even spoken to the police about this.
All right, this is what the court is going to do. The court is finding you guilty. The court is going to sentence you to 1 year in the state jail facility, suspended and probated for 3 years. There's $1,000 fine to be probated, concurrent with County Court Cause number 685703. Restitution, if any, to Austin Galan. There's to be regular reporting by Zoom or in person. There's to be random UAs. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And who is the gentleman you said you're going to be staying with?
His name is Joe De Hoyos.
Joe what?
De Hoyos.
All right, and there's to be probation. This gentleman that she's staying with, he is not an appropriate chaperone for her to be seeing her children. So when I say no unsupervised contact with minors, that person cannot be used as a chaperone. You said it's Joe De Hoyos. That's odd that her attorney name is Joanne De Hoyos. And she's saying that the guy she's living with is Joe De Hoyo. Okay. See what I mean where what Mr. states when I say I have concerns about her?
His name is Joe Anthony De Hoyos.
Okay. So there's no, you know what? There's just to be no unsupervised contact with minors, and whoever she's living with at the time is not to be a chaperone. So there's to be no chaperone of children by defendant's paramour or significant other. There's to be 120 hours of community service restitution. 40 of those hours will be waived if you can provide COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be parenting classes. You to complete those parenting classes, and once you complete those parenting classes, the remaining of the community service hours will be waived. I really do think you need CATS 1 and 2. My CATS 1 and 2 class is not enough for you. There's going to be field visits. And that's going to be 2 times per month until further notice. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court in order to be successful? Showing you was entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to consult with an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, you got to do better. The stories that you're telling me, you wouldn't take that from any child telling you. You understand?
I'm
All right, good luck to you.
Thank you. I'm being completely.
And Judge, just,
All right,
just
so we'll be
the court's
back.
aware, she will be in custody until County Court 14 case is resolved.
All right, so you'll be in custody until County Court 14 case is completed and probation. The time for her to begin looking for employment, that's to begin once she's released from custody.
Yes, Your Honor.
All right, so we will be back tomorrow at 9 a.m., I believe. Oh, are we back tomorrow at 9 a.m.? It's the Wednesday?
Yes.
We have cases set? All right, so we'll be back at 9 and then we'll do jury selection.